Hello from the John Marshall Law School's Domestic Violence Clinical Advocacy Program, the producers of this educational video. More than 8,000 people in Cook County, Illinois seek orders of protection each year. We are dedicated to creating innovative legal resources that are accessible to all survivors of domestic violence in Illinois. In this educational video, you will learn what to do in a hearing before a judge after receiving an initial emergency temporary order of protection.
All rise, the Honorable Judge Marshall presiding.
Good morning, everyone. This is the Order of Protection Court Call. I'm Judge Marshall. When you hear your name and case number, please approach the bench and state your last name. 150P0319, Hardigan v. Slippett. Who are you, ma'am?
Audrey Hardigan.
Is Mr. Slippett present today?
No, I haven't seen him, Your Honor.
Was he served with a petition for the order of protection?
As you have seen, the first question the court will typically ask is whether the respondent was properly served with court documents. Proper service puts the respondent on notice that he or she must appear in court for the court date or face a default judgment entered in the petitioner's favor. A default judgment is entered by the judge when only the petitioner appears on the court date. There are two ways to properly serve a respondent with the petition for a plenary order of protection. The first is through the sheriff's office, and the second is through a special process server. To get service completed by your local sheriff's office, take the summons, one original, 2 copies, each having attached a copy of the complaint, to the sheriff to arrange for hand delivery to the respondent. Once the sheriff serves the defendant, the sheriff fills out a sworn statement called an Affidavit of Service. On the back of the summons copy, the police will then serve the respondent and return the Affidavit of Service once the respondent has been served. Service by the sheriff for orders of protection are free under the Illinois Domestic Violence Act, so this should be your first method to obtain service. To improve your chances, provide as many last known addresses as possible. Home, work, or other places the respondent is likely to be and at what time of day. If the respondent personally comes to you, call the police immediately, informing the police there is an outstanding order of protection and asking them to issue a short form service if the respondent has not yet been served. If you cannot get the respondent served through the sheriff, or if you want more certainty about the time, place, and manner of service, you can pay for a special process server. In Cook County, you need permission to use a special process server. In all counties, this person must be licensed. The court does not maintain a list of special process servers. You will have to find a licensed professional on your own. After the respondent has been served by the sheriff or special process server, you should receive what is called an Affidavit of Service. This piece of paper shows the court that you had the papers served in the correct way. The court will look for the date the papers were served, where the papers were served, who the papers were served on, a physical description, and the name and address of the person who served the papers.
I'm not sure if Mr. Slippett has been served. I gave the sheriff the summons to serve him.
Do you have an affidavit of service?
Yes, Your Honor.
Okay. Mr. Slippett was properly served, so he knew about today's court date, but fails to appear. What would you like me to do for you in light of that?
As the judge pointed out, the respondent has been properly served and is on notice that today is the court date for which he must be present. At this point, it is up to you to ask the judge to enter a default judgment in support of your petition for a plenary order of protection.
Your Honor, I ask this court enter a default judgment in favor of my petition for an order of protection.
Okay, I'm going to have to put you under oath. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
For the record, state your name, spelling your last name.
Audrey Hartigan, Hartigan.
Okay, is this your petition for an order of protection against Mr. Slippet?
Yes.
Okay, are all the allegations stated in this petition true and accurate to the best of your knowledge?
Absolutely, Your Honor.
All right. Show that the petitioner, Ms. Audrey Hartigan, is present in open court, pro se, and the respondent, Michael Slippet, was properly served but failed to appear in open court or give notice otherwise of his absence. Court has had an opportunity to review the statement of facts in the petition for the order of protection. This court finds that physical abuse, harassment, and intimidation of a dependent has occurred and would likely occur if this court did not grant the order of protection based on the testimony presented in the petition. So this court finds that petitioner has met her burden of proof for an order of protection. Order of protection is going to be good for 2 years, November 4th for the termination date. There is to be no contact whatsoever by the respondent with the petitioner. That the court finds the petitioner has proven by a preponderance of evidence that on October 26th, petitioner was physically abused by the respondent. That the court further finds that the burden on the petitioner to move from the residence outweighs that of the respondent, and that the respondent has alternative housing. Thus, the court grants exclusive possession of residence to the petitioner. That the court finds that the physical abuse occurred in front of the minor child, Jace Maddox Hartigan, and as such finds a danger to the safety of the minor child and denies to the respondent unsupervised visitation. That the care and physical possession of the minor child shall remain with the petitioner. Have a good day, Ms. Hartigan.
Thank you, Your Honor.
As you have seen, Ms. Hartigan's petition for a plenary order of protection has been granted. The judge was able to enter this order against Mr. Slippet without him being present because he knew he had to appear in court that day. The judge noted several forms of abuse by their statutory defined terms: physical abuse, harassment, and intimidation of a dependent. Please see our clinic webpage's Public Resources section for a link to a good explanation for laypersons. The judge also referred to some of the many remedies a person seeking an order of protection might qualify for. Please see our clinic webpage's Public Resources section for links to a good explanation of these remedies. For now, let's rewind a bit to the judge's question if Mr. Slippet was served and see what Ms. Hartigan can do if Mr. Slippet is not served.
Was Mr. Slippet served?
I'm not sure, Your Honor.
Madam Clerk, could you look up to see if Mr. Slippet was served?
No, Your Honor. Mr. Slippet has not been served.
Thank you, Madam Clerk. Okay, Mr. Slippet was not served with your petition for an order of protection. And since he is not here, I can't do anything for you until he is served. Is there anything else you'd like the court to do today?
Your Honor, may I ask this court to grant me a continuance to serve him and extend the emergency order of protection until we return to court?
Okay, before the next court date, you need proper service on the petition to Mr. Slippet. I'll set this out for 21 days and extend the temporary order of protection to that date to obtain service.
Thank you, Your Honor.
If at the return date you still don't have service, don't panic. Here are your options. You can ask for an additional continuance. Be sure you have a good address for where the respondent can be found, including not only where the respondent lives, but also other places where the respondent may be found, such as a respondent's parents' home, and respondent's place of work. If you do not appear to have any good addresses to find and serve the respondent after 3 continuances, the judge will allow the complete service through publication. As the name suggests, service by publication is placed in a newspaper. By obtaining service by publication, you will still be able to obtain a plenary order of protection, but the respondent will need to actually know about the plenary order of protection to be criminally charged with violating it. Once you have a plenary order of protection, if the respondent contacts you or does other action in violation of the order, you should call the police immediately. If the police state that they cannot arrest the respondent for violating the order of protection because the respondent was only served by publication rather than personally served, ask the police to perform their duty to provide a short form of notice to the respondent. Once the short form of notice is provided to the respondent, if the respondent fails to stay away from you as required by the order, he or she can be arrested and face criminal charges.
And who are you, ma'am?
Audrey Hardigan?
And who are you two?
Alex Del Rey, attorney for the respondent, Michael Slippett, present today in open court.
Let the record reflect that both parties are present. Ms. Hardigan appears pro se. Mr. Slippett appears represented by attorney Alex Del Rey.
You can also ask for a continuance in another situation. In this scenario, Mr. Slippett is present with an attorney when the case is called forward by Judge Marshall.
And who are you, ma'am?
Audrey Hardigan?
And who are you two?
Alex Del Rey, attorney for the respondent, Michael Slippett, present today in open court.
Let the record reflect that both parties are present. Ms. Hardigan appears pro se, and Mr. Slippett, represented by attorney Alex Del Rey.
Your Honor, may I have a continuance to find an attorney?
I'm fine with that. I'll allow it if counsel is all right with setting this out for 21 days.
Most judges in Cook County would grant a continuance in this situation, but judges outside of Cook County are less likely to grant a continuance, especially if it appears to be a stall tactic by the petitioner, since the respondent has the right to a hearing at the return date unless good cause is shown.
I'm giving you 21 days to find an attorney. If you don't find a lawyer by then, this case will go to hearing. I will extend the emergency order of protection in light of the facts stated in the petition, but I cannot extend it any further. Does that work for both parties?
That works for us, Your Honor.
As you can see, Mr. Slippett has hired an attorney. The process for obtaining a plenary order of protection can be difficult when the case goes to a hearing before a judge. In this next scene, our two parties, Ms. Hardigan on one side and Mr. Slippett, represented by Mr. Del Rey on the other, have proceeded to a hearing before Judge Marshall. Ideally, the multitude of resources available to you will be able to get you in contact with an attorney to represent you through what is called a contested hearing. Whether you have an attorney or not, the most important thing you can do before the contested hearing is to carefully reread the petition to refresh your memory of the facts you stated in the petition on what the respondent did to you. It is not enough to say you are afraid of the respondent. You need to be able to testify to the facts that led to this fear and be able to tell the judge what happened to you. You should bring your petition and the emergency order of protection you received with you to the hearing. You should also bring any documents you want to show the court, including text messages, Facebook messages, emails, phone messages, and photos of the abuse. For example, in Will County, you cannot bring a phone into the courtroom building without first obtaining a court order to do so, something you can ask for and get before your court date. Returning to the scenario, at times you will hear Mr. Del Rey interrupt Ms. Hardigan by saying, "Objection," along with the reason for the objection. A party can raise an objection when the other party tries to tell or show the court what happened in a way that violates the rules of how or what kinds of evidence a person can raise. When an objection is called, it is then up to the judge as to whether the reason for the objection is valid and sustains the objection, meaning the question will not be answered, or if the judge does not find the objection valid, the judge will overrule the objection, meaning the question should be answered.
Okay, Ms. Hardigan, you may begin.
My name is Audrey Hardigan, and I used to date Michael. He's the father of my baby. On several occasions, Michael has hurt me and caused me to fear for my life and my child's life. On October 26th, Michael attacked me and was arrested after the police found him. I was getting ready for work.
Objection. Foundation. The location wasn't stated, nor was the time.
Okay, sustained. Ms. Hardigan, just to clarify, where were you on that date and what time of day was it?
An objection based upon the foundation of evidence or testimony you wish the court to see or hear is one of the most common. The key is to talk about the who, what, where, and when of the story. Here, Ms. Hardigan has correctly spoken of the who by saying that it was Michael who attacked her, and the what by saying how the things she is saying is relevant to her needing an order of protection. As stated by Mr. Del Rey, all she is missing is the when and where. To get you more comfortable with the subject of laying foundation, let's take a look at a couple of more examples of establishing foundation.
I used my cell phone to take pictures of myself after Michael attacked me on October 26th at my home. I printed the pictures out.
How many pictures did you take?
3, Your Honor.
To the best of your knowledge, are these 3 pictures a fair and accurate representation of how you looked after the October 26th incident?
Absolutely, Your Honor.
If you want me to see them, please hand the pictures to Mr. Del Rey. Any objection to entering the photographs into evidence?
No objections, Your Honor. Foundation was properly laid.
Let the record reflect the court has viewed the photographs labeled Petitioners Exhibit A, B, and C.
Here, Ms. Hardigan has successfully established the who. She is the one who took the pictures, and the what are the pictures of, and what is the situation surrounding taking of the pictures, and whether or not the pictures accurately show the court how she looked on that day. The when, the pictures were taken directly after October 26th incident, and the where, the pictures were taken in Ms. Hardigan's home. Now you're probably wondering why Ms. Hardigan had to show Mr. Del Rey the pictures. She also properly labeled each of the documents at the top of the document as Petitioners Exhibit A, B, C, etc. All evidence must be acknowledged and examined by both parties to ensure that the photographs or other documents are valid and have a reason to be presented to the judge. Other types of evidence you wish the judge to consider follow many of these same basic principles. While some things may seem obvious to you, it is still necessary to testify to certain basic facts, such as how to recognize a phone number, because you will have used it or saw it many times. Another issue that comes up often is testifying that you knew someone was intoxicated. If an objection is raised as to how you knew that, you should be comfortable to say, if the case, that you could smell the respondent's breath or saw the respondent drinking that day, or have seen how others who are intoxicated have acted.
Your Honor, I have numerous text messages from Michael that are threatening and disturbing. The first one goes from September 30th and the last one from October 25th. My number at the time was 555-926-5678, and Michael's number was 555-489-1234. I've gotten at least 3 text messages a week in that time from Michael. All of them have been either threatening to myself or to my son now, more recently.
All right, let's focus on the most recent message. Let me see it.
Did you catch what Ms. Hardigan added into her testimony to bring in the text messages from Michael? Ms. Hardigan had to expand the WHO umbrella of establishing a foundation for the text messages to include the phone number seen in the text message. Here, Ms. Hardigan identified that the phone number that sent her the threatening text messages was a number she recognized as Michael's to a phone number that was registered to her. Since the abuse stretched across a long time period, Ms. Hardigan merely has to establish the first and latest message received to establish the when umbrella. In our modern age, the where umbrella has become less reliant on where the message was received geographically and more reliant on the manner in which the message was delivered. Now that you have some basic tips about establishing the foundation for your evidence using the 4 W's umbrella, let's move on to other types of objections.
Where were you on that date, and what time of day was it?
On October 26th, I was getting ready for work in the morning when I heard a knock on the door. I open the door and Michael rushes in and asks me where the baby is. Then he picked me up by the jacket and was yelling all of these obscenities at me. I could smell on his breath that he'd been drinking.
Objection. Narrative.
All right, sustained. Ms. Hardigan, please just answer the question of where you were on October 26th and what time of day it was.
To clarify, Mr. Del Rey's objection was not the substance of Ms. Hardigan's testimony. Here, Mr. Del Rey had asked a specific question to Ms. Hardigan about the where and when, not about anything else. It is natural when presented with a question to go beyond what is asked of you, as happened here. The best way to counteract this natural tendency is to take a breath and listen to the questions asked of you. We cannot stress enough that there was nothing inherently wrong with what Ms. Hardigan said, but in the courtroom, everything has a time and place to be spoken of. Let's move on to a different objection.
Michael said that he was going to make my life miserable. He could kill me right now. Nobody would care.
Objection. Judge, outside the scope of the petition, it's not listed in the petition that any threats to her life were made, specifically those words that she just mentioned. Judge,
Page 4 of the petition does not indicate there were any.
any threats of killing or making Ms. Hardigan's life miserable.
It says here that he threatened her life, threatened to hurt her, threatened to hurt their son. Overruled. Please continue, Ms. Hardigan.
One thing to keep in mind throughout the process of obtaining a plenary order of protection is to make sure to let the judge know all of the reasons why you need to be protected by the order. Understandably, it is difficult at times to discuss the troubling experiences, but your goal in the entire situation is to simply explain the dire situation to the judge. Typically, details like this wouldn't be subject to this objection. It's more likely that this objection would be made if you were to testify to an entirely new or additional incident that you did not write about in your petition for the order of protection. Most judges appreciate that you may not remember specific details of every threat made in the long history of abuse. If the respondent has violated the stay away and no further contact remedy after you receive the emergency order of protection, you may want to ask the court if you can amend your petition and its affidavit to describe what happened.
My friend told me that she saw Michael pull me out of the car by my hair.
Objection. Hearsay. Sally is not present in court for me to cross-examine, and petitioner is trying to impermissibly use this alleged statement to Sally as evidence that my client has pulled her hair.
One of the strangest creatures of evidence law is hearsay. Ms. Hardigan is telling the judge what somebody has told her, even though the other person is not in the courtroom. And the purpose of saying what that person said is to prove the truth of what was said. In this case, Mr. Slippett had indeed pulled the petitioner's hair.
Objection sustained. You cannot tell me what your friend told you she saw to prove what she saw happened. You need to bring your friend into court to testify as to what she saw and provide the respondent with the opportunity to cross-examine your friend on what she saw.
Hardigan can testify that she saw her friend Sally present when Michael pulled her out of the car by her hair. She cannot testify to what Sally allegedly saw or heard.
It was the day after the 4th of July. We were at our place at 123 State Street. It was late in the afternoon, and Michael and I were watching TV. He had been drinking all day. We had gotten in an argument, and he pushed me down and spit in my face. He tried to pick me up and throw me down the stairs. I was pregnant with our son at the time, around 7 months, I guess. I didn't know what to do. He had always had a bad temper when he was drinking, but since then, since I had gotten pregnant, Michael just sort of lost it. I'm terrified.
Objection. Her testimony calls for pure speculation.
If the attorney for the respondent objects to what you have stated, and you are not sure what part the attorney is objecting to, be sure to ask what portion of your statement he is objecting to, so you can better respond to the objection to the judge.
Objection. Her testimony calls for pure speculation.
What testimony did I just provide that you're objecting to, counsel?
When you said, Michael just sort of lost it,
I think her statement goes to her state of mind. She's saying why she's afraid of him, so that's overruled.
In this example, Ms. Hardigan has successfully outlined the who, what, where, and when of her testimony. Here, Mr. Del Rey has highlighted an important reason to disclose all of the reasons you are seeking the order of protection. Judge Marshall's ruling hinged upon the notion that Ms. Hardigan is describing how she felt at the time of the incident. Fear, distress, and sadness are just a few of the many feelings that may be running through Ms. Hardigan during Mr. Slippett's abusive actions. And judges generally will take that into consideration for granting a plenary order of protection. In the courtroom, it is entirely natural that your emotions will run high. One thing that you must prepare yourself for is hearing what the respondent has to say about the situation. As highlighted earlier in this film, the judge's role is to view the entire picture of the situation. After you have finished speaking, it will then be the respondent's turn to testify. If during the respondent's testimony you hear him or her lying or not telling the whole truth to the judge, do not fret. You will have the opportunity to question the respondent about what he has said when he is through speaking. It is very important that you do not interrupt the respondent's testimony and call that person a liar. The judge may see you as an angry or hostile person, and this may hurt your chances of receiving an order of protection. Let's now see how Ms. Hardigan handles her cross-examination of the respondent.
Michael, you admit that you grabbed me by my jacket?
Yes.
And you admit that you said you would have other people do things to me?
What I meant by other people, I didn't mean it as a threat.
So when you said, I better not see you on the street, that wasn't meant as a threat?
No.
Okay. Show the parties are present in open court. Court has had an opportunity to hear the testimony of the parties, to observe their demeanor when testifying, and to weigh their credibility. Court is going to find.
You made it. Congratulations. Regardless of the outcome of the case, you have been through the process of a contested hearing. Either your plenary order of protection has been granted or your plenary order of protection has been denied. Let's take a look at how Audrey handles each of the scenarios.
This court finds that physical abuse, harassment, interference with personal liberty, and intimidation of a dependent has occurred and would likely occur if this court did not grant the petition for a plenary order of protection based on the testimony of the parties and other evidence presented. Petitioner has provided credible evidence that the respondent has done more than argue with the petitioner and has engaged in physical violence and threats of physical violence in front of their children. Petitioner has met her burden of proof for a plenary order of protection and will be granted the remedies sought in her petition.
Thank you, Your Honor.
Be sure that you understand the terms of the order granted, and if anything in the order is unclear to you, ask the judge to clarify it. If the respondent has violated the terms, such as continuing to contact, harass, or injure you, it is imperative that you contact your local police department right away. Keep a copy of the plenary order of protection with you at all times and provide copies of it to your employer or to those who are in any other location where the respondent has been ordered to stay away from.
This court finds the petitioner has failed to meet the requirements necessary for a plenary order of protection and denies the petition.
Although it sounds discouraging to hear that your order of protection has been denied, there are still some options open to you. First, notice that Judge Marshall has not clarified in what way did petitioner fail to meet the requirements necessary for a plenary order of protection. If you find yourself in a situation such as this, ask the judge what was insufficient about what you presented. What wasn't enough? Was something lacking in the statutory requirements? The Order of Protection statute in Illinois requires that there be a certain kind of relationship between the parties to obtain an order of protection. Most common examples include a dating relationship, if you have a child in common, you both lived in the same dwelling, or you are related by blood or marriage, including former spouses. The statute also requires that some form of abuse occurred. Abuse means physical abuse, harassment, intimidation of a dependent, interference with personal liberty, or willful deprivation. These terms have precise meanings that you can learn by referring to the links in our DV Clinic web pages public resources section we noted earlier. But what should you do if the judge does specify what was insufficient about the evidence you provided?
This court finds that the petitioner has provided insufficient evidence to show that abuse has occurred. Based upon the testimony presented, it is clear that there have been arguments between petitioner and respondent that has led respondent to strike petitioner on more than one occasion, but there is also credible testimony that petitioner has also struck respondent. This appears to be a case of mutual fighting, so this court finds that there is insufficient basis to grant a plenary order of protection. Petitioner has not met her burden of proof.
If a petitioner has struck the respondent, a court might find that there has been mutual fighting and deny granting an order of protection. If, however, the petitioner struck the respondent in self-defense, then this should not be seen as mutual fighting, and the judge should not deny a plenary order of protection on this basis. So it is important for petitioners who struck someone in self-defense be sure to explain in their testimony to the judge why they felt at the time that it was necessary to strike the respondent to protect themselves from further physical harm. If you provide this testimony and the court still denies the order of protection, you can say, "Your Honor, I request the court to reconsider this ruling. May I seek counsel to argue for a reconsideration of your ruling?" If the court denies a reconsideration, you can then contact an attorney to see if the ruling to deny the order of protection was an error and can be appealed. But note, the appeal must be filed within 30 days of the court ruling to deny the order of protection. We hope that by giving you a sense of what can happen at a plenary order of protection hearing and the ways that you can respond to what happens, this will improve your chances of obtaining the legal protections that you seek. We also hope it empowers you to overcome any fears that you may have about returning to court because you do not know what to do or say at this hearing. Another reason why some people are fearful about returning to court to obtain a plenary order of protection is the concern that the respondent will attempt to come into contact with them at the courthouse. Some courthouses, such as the one at 555 West Harrison, offer a special room you can go to. If there is no such room at the courthouse where your hearing is taking place, go to the clerk or sheriff's officer in the courtroom where your case will be heard and tell them of your concern that the respondent not sit near you before the case is called. You can also ask them to arrange for a sheriff's officer to escort you after your hearing to your car or to the form of public transportation you will be using. It is very helpful for you to arrive at the courthouse an hour before the time your case is to be heard, so that you have ample time to go through the security line and speak to the sheriff and/or sheriff's officer on your safety concerns. We have posted on our webpage other tips for you when you are appearing in court for a plenary order of protection under the Public Resources page. As you know, an order of protection is just one step in becoming safe. You can speak with a domestic violence advocate to gain more insights on your level of risk and other steps you can take to become more safe. If the violence and other forms of abuse you have suffered were part of a pattern to coercively control you, it is very possible that the act of separating from your abuser may trigger a violent reaction. So it is critical that you obtain assistance in safety planning. For contact information for a DV service organization near you, if you live in Illinois, you can contact the confidential 24-hour State of Illinois Domestic Violence Hotline, toll-free at 877-863-6338. That is 877-2-END-DV.
Hello, my name is Deborah Stark, and I'm the director of the John Marshall Law School's Domestic Violence Clinic. This video is one of several public resources our clinic has created to empower survivors of domestic violence to exercise their rights under the law, even when not represented by an attorney. If you go to our clinic webpage, you can access these resources, which include a transcript of this video, FAQs on divorce and parentage laws, and interactive online legal resources that enable you to determine if you qualify for certain forms of legal relief. followed by pop-up tips in the forms you need to fill in order to obtain the legal relief. Our clinic also provides comprehensive legal representation to survivors of domestic violence to help them and their children become safe and financially independent. We offer legal assistance to survivors of domestic violence in 8 practice areas: orders of protection, divorce, parentage, and child protection cases, immigration relief, housing and employment protections, crime victim compensation, debt relief and credit repair, and federal and state income tax liability relief. To be eligible for direct legal representation with us, you need to be referred by a domestic violence service organization that has first worked with you on risk assessment and safety planning. Wishing you and those you love safety, justice, healing, and renewal.